Finally, an update on our electric vehicle tax High Court challenge. What's been going on since we lodged it, where are we now, and what comes next? Yesterday, my lawyers, Equity Generation, sent out an update to 628 individuals who chipped in to support our case to the High Court of Australia. As a reminder, July 21, the Victorian Government's controversial tax on electric vehicles and plug-in hybrid vehicles became a reality for thousands of Victorians. Charged at 2.5 cents per kilometre driven for EV drivers and 2 cents for plug-in hybrid owners, on July 1, 2022, that increased to 2.6 cents and 2.1 cents per kilometre respectively. We're arguing that this tax by the Andrews government on electric vehicles and plug-in hybrid vehicles is unconstitutional. Victoria doesn't have the legal right to tax road users for a fee. It's merely a cash grab that punishes Victorian families who have decided to transition to cleaner cars that are better for the environment and better for our children's health. Heck, even Tim Pallas has said at last year's Federal Treasurer's meeting that he was unashamedly attempting to siphon the federal government's fuel excise revenue stream using Victoria's controversial electric vehicle tax. He was challenged by then Federal Treasurer Josh Frydenberg, who suggested a national approach was needed, but Mr. Pallas bluntly rebutted him and said to, keep out of it, and not on your Nelly. That's a revenue stream that we, the state of Victoria, needs, and you keep out of it. And to be entirely frank, every other state and territory agreed with me. As you'll soon learn, his words are very true, so buckle up and come with me on a brief of what's been going on behind the scenes. G'day and welcome, my name's Chris and I cover technologies like electric vehicles from an Australian perspective. If you're new here, please consider subscribing. Okay, almost 10 months ago since we first lodged our case with the High Court of Australia, a lot has been going on behind the scenes. Myself and Kath are the plaintiffs and we need to be cautious as to what we say publicly so that we don't derail this legal challenge. Since the High Court case was filed in September 2021, we and the State of Victoria have filed pleadings with the court covering the technical aspects of what we are arguing as something that Victoria cannot charge for. That included a statement of claim, that the state's defence, and a reply to the state's defence. We've agreed on a document called a special case, which is essentially a summary of factual and legal issues most relevant to the court for the determination of proceedings. Recalling Mr. Pallas's words from earlier on how every state and territory agreed with him, this is where things get really interesting. Here's why. Do you live in a state that hasn't announced a new tax on electric vehicles and plug-in hybrids? Do you think that you're safe and this is just a Victorian thing? Well, what if I told you that every state, including South Australia, who recently abolished this tax, has formally submitted to the High Court, stating that they stand with Victoria? Yes, New South Wales, Queensland, Western Australia, South Australia, Tasmania, they've all become interveners on behalf of Victoria. In constitutional cases, the Attorney Generals from the Commonwealth and each state are permitted to appear before the court. The legal arguments in this case relate to the division of taxation powers between the states and the Commonwealth, and unsurprisingly, each state's Attorney General has intervened in support of the state of Victoria. But, and it's a big but, last week the Commonwealth Attorney General intervened to support Kath and I. This is important and significant, and it will mean, I can't say, or can I? Probably best I don't. Again, we don't want to upset the court processes. There's been some boring exchange of documents, there's been evidence collection and submission, nothing terribly exciting. And between now and the end of September 2022, we, the State of Victoria, and the interveners, that's all the other states and federal attorney generals, will have the chance to file submissions. Now, read that as legal arguments. So this will all happen to go to the High Court of Australia. At some point after the submissions are filed, a hearing date will be allocated. Now, returning to that recent price rise, sure, It's just like 0.1 of a cent rise. But times that by your typical driving distance per year, by the number of EV and plug-in hybrid owners in Victoria, and the state is going to reap more than $100,000 extra per year in money that, again, we argue Victoria cannot validly collect. It's unconstitutional. That price difference represents a 4% rise, and if you're a high miler, that can actually represent not the $10 to $15 extra per year, but maybe hundreds of dollars. The controversial thing about this price rise is that the Section 17(2)(a) of the Act allows the Secretary to make an estimate of the amount if the period for which a charge is determined falls in more than one financial year, and the rate of the ZLEV charge for each of those years is different. Put that another way. One half of the year there's one charge rate, and the other half of the year there's another charge rate. And so if you don't then provide them with evidence, how are they going to calculate that? Okay? So what did I do? I went and asked Vic Roads, how will I submit an odometer reading for up to July 1? Because my rego is due December 30. And they said to me, there's no way you can't submit it. We don't have the ability to do that. So is it fair that any kilometers I do from now to the end of this year are going to be averaged across the whole year at a pro rata rate? What if I did a lot of kilometers at the start of the year, let's say 10,000, and the second half of the year I left it somewhere and it did 1 kilometer? I'm going to be unfairly charged, levied, taxed, whatever you want to call it, for kilometers at that higher rate. Is this legislation fair? No. Is it sensible? No. There's a lot more I can say here, but you get the idea. If you haven't already, take a photograph so that come whenever your registration is due and they say, oh, pro rata, your charge amount is this, you should try to give to them perhaps a little bit of evidence and say, this is how many kilometers I traveled to this date, that is June 30. Something to park just ready for later. I find it deplorable that the state government is taxing EVs when they have proven health benefits and better climate outcomes for everybody. With your help and equity generation lawyers, we soon hope to argue in the High Court of Australia that the state of Victoria lacks the constitutional power to levy a road user charge on EV drivers. If successful, we'll see this regressive backward tax scrapped, not only for Victorians, but also all Australians. So now you can understand why I've been so passionate about this, because it doesn't only affect Victorians, it's actually going to affect all of Australia. If you have already contributed to the Chuff Fund, thank you. We really do appreciate it. If you haven't already, follow the link down below, because your help will actually get us to a successful outcome in this case. The stakes are high, and Kath and I are prepared to take this to the nth degree. So if you can, please do support this case. It really does help. And if you haven't already, subscribe. I'll try to keep you updated as best I can. But otherwise, be good, be great.